Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. We're going to get to talk about a state that we have not yet had a chance to geek out on here on Washington Gun Law, and that is the state of Virginia. You know, they say that elections have consequences, and there was an election earlier this month, and things didn't go quite the way we had hoped in Virginia, and now the Democrats control both chambers of the state legislature, or will take control of that early in 2024. And with that, well, along comes the civilian disarmament bills. Not one, but two have been pre-filed in the state of Virginia. We need to talk about what they do, how they do it, and most importantly, what is the likelihood that these might actually come to fruition and be turned into law. So today, let's spend a few minutes, let's geek out, and let's talk about the two bills introduced in Virginia to ban assault weapons. Okay, what we are talking about today, Virginia, is House Bill 2 and Senate Bill 2, two pieces of legislation that have been pre-filed in the Virginia State Legislature that, if either one was enacted into law, would serve as an assault weapon ban in the state of Virginia as well as a high-capacity magazine ban in the state of Virginia. Now, some caveats for those of you who have not geeked out with us here at Washington Gun Law. Number one, I am going to use the term assault weapon only because that is the term that's used in the statute. Number two, I will also use the term high-capacity magazine or how it's listed in the statute, even though we all agree that those are standard capacity magazines. Number three, I am not doing this video to try to scare all of you to death or to make you think that this is actually going to happen. You will see at the last section of this video that we're going to talk about what the likelihood is that this actually becomes law. And candidly, Virginia, it's not real good, at least with the current political makeup of your state. Now, anytime we see high-capacity magazine restrictions or assault weapon bans, what we do is we take a look at the language in the bill, and we typically find that it was cut and pasted from some other states. If you take a look at all the attempts that Washington State made at an assault weapon ban, every single word of any bill that we ever proposed here in Washington was cut and pasted directly from California legislation. The first question I know that all of you have is okay, if this does become law, is there a grandfathering provision? That is, if I own one of these firearms, which are now banned, can I keep it? The answer is yes, you can, but they're doing it in a far different way. So there are some nuances to this law that I want you to be aware of, because I've not seen this type of wording in certain statutes. I haven't seen this mechanism for doing it. And I'm concerned that what the Virginia State Legislature would be doing is setting you up to then amp these laws up with really just changing a couple of words. Now, in Washington State, when we passed our assault weapon ban, we grandfathered firearms in by prohibiting the sale, offer for sale, manufacturing, transferring, or importing of semi-automatic rifles. What we did not do was ban the possession of them. However, both House Bill 2 and Senate Bill 2, if enacted into legislation, specifically read, any person who imports, sells, manufactures, purchases, possesses, transports, or transfers an assault firearm is guilty of a Class 1 misdemeanor. Okay, so you see that and you go, well, how on earth are they actually going to grandfather these firearms in? They do so by changing the definition of what constitutes an assault firearm. Currently, under Virginia law, an assault firearm is defined as: assault firearm means any semi-automatic centerfire rifle or pistol which expels a single or multiple projectiles by action of an explosion of a combustible material and is equipped at the time of the offense with a magazine which holds more than 20 rounds of ammunition or designed by the manufacturer to accommodate a silencer or equipped with a folding stock. Now, if either of these two bills become law, the definition of assault firearm in the state of Virginia is going to change significantly, and it's going to change also based upon the platform of firearm. The new definitions, if enacted into law, would include: assault firearm means 1, a semi-automatic centerfire rifle or pistol that expels a single or multiple projectile by action of an explosion of a combustible material with a fixed magazine capacity in excess of 10 rounds. But wait, there's more, because then we're going to break it down by rifle and pistol and shotgun. 2, a semi-automatic centerfire rifle that expels a single or multiple projectile by action of an explosion of a combustible material that has the ability to accept a detachable magazine and has any one of the following characteristics: And then the characteristics, and you can look up the legislation below, we'll link it up, is anything that you're typically going to find on an AR or AK platform. So it's going to include a pistol grip, it's going to include a muzzle brake, a flash hider, a threaded barrel, a barrel shroud, or anything else commonly associated with that platform of firearm. But there's more, including pistols, because there would be a new definition which would state a semi-automatic centerfire pistol that expels a single or multiple projectile by action of an explosion of a combustible material that has the ability to accept a detachable magazine and has any one of the following characteristics. And one of the characteristics that they're going to mention is accepting a magazine in some place other than the pistol grip. And then they're going to list all the other components that you might typically find in your typical carbine platform and say that the existence of any one of those makes it a banned weapon. I mentioned that there was going to be shotguns on it. There are. The new definition would read, a semi-automatic shotgun that expels a single or multiple projectile by action of an explosion of a combustible material that has any one of the following characteristics. And then one of the things it lists right away is a pistol grip. So any of your more tactical semi-automatic shotguns, well, those would become banned assault weapons as well. So you hear all of this and you go, well, wait a second, how do they grandfather it in? Well, there's one exception to the definition of what an assault weapon would be, and it's this. An assault firearm does not include any firearm that is an antique firearm, has been rendered permanently inoperable, is manually operated by bolt, pump, lever, or slide action, or was manufactured before July 1st, 2024. So any of these types of weapons, if this became law, that was manufactured before July 1st of 2024 would not fall under this ban. Now, you understand, Virginia, that in a year or two, if this became law, all it takes is a legislator to strike those last 4 or 5 words from that definition, and now every single semi-automatic rifle, every single carbine, all constitutes unlawful and banned assault weapons. Now, I know you're also asking, what about all the magazines I own? Would those also be grandfathered in? The answer is yes. And again, we're in Washington. We limited the sale, offer for sale, importation, manufacturing, or assembly. We did not prohibit the possession of such. This statute would in fact prohibit the possession of any large capacity ammunition feeding devices. That's what the state of Virginia calls it. But the definition has a very unique nuance to it. The definition, if enacted into law, would read, as used in this section, a large capacity ammunition feeding device means a magazine, belt, drum, feed strip, or similar device manufactured on or after July 1st, 2024, that has a capacity of, or that can be readily restored or converted to accept more than 10 rounds of ammunition, but does not include an attached tubular device designed to accept and capable of operating only with .22 caliber rimfire ammunition. Now, the big difference here between firearms, which are manufactured after a date certain, is we can usually figure out what date those firearms are manufactured. In fact, the serial number often tells us that alone. And then, of course, there's a 4473, which will tell us on what day that individual took possession of the firearm. When it comes to magazines, there is no serial number. We have no idea when they were manufactured, unless it's a proprietary magazine to a brand new gun. Most magazines have been around for many, many years. And the truth is nobody can tell the difference between the 30-round PMag you bought 3 years ago, the one you bought a year ago, and the one you're going to buy in 2 years. Now, in addition to all of that, there would be some other offenses that if you commit them on a criminal level, they would also result in disqualification of your Second Amendment privileges. We're not going to get too far off the beaten path and get into that today. Here's the $64,000 question, right, Virginia, which is, what's the likelihood that this comes to fruition? What's the likelihood that this actually becomes law? I would tell you right now that if you just do the math, it's probably pretty slim. As we know, we did not have a particularly good election in November, and the Republicans lost control of the one house they did control. So currently, there is a 2-seat majority for the Democrats in the Senate. There is a 2-seat majority for the Democrats in the House of Reps. Very, very narrow majority. In order to pass out of both of these chambers, you would need every single Democrat in both chambers to support this legislation. But even if it passed out of the Senate and the House, it would go to Governor Youngkin's desk, which he has the power of veto. And if he were to veto this bill, it would go back to the House of origin. So, for example, if House Bill 2 was the one that got to the governor's desk and he vetoed it, it would go back to the House. The House would have to override the veto, and they could not do so unless they got 2/3 of all members of the House to actually vote to override the veto. But even if the House of origin were to override the veto, the bill would then go to the other chamber and it would need a 2/3 vote there as well. So when you start just crunching the numbers and doing the math, the likelihood that this is even going to get to Governor Youngkin's desk is pretty remote. The likelihood it survives that is even slimmer than that. So here's the thing you also need to be aware of, though. In Washington State, we just passed our assault weapon ban here in the spring of this year. That was not the first, not the second, not the third, but actually the 7th attempt at that legislation. 6 years prior, the same piece of legislation had been proposed, and for one reason or the other, it never came to fruition. Now we're living under the guise of an assault weapon ban, which is currently under court challenges. The bills, once again, are House Bill 2 and Senate Bill 2. We'll link them up both down below so that you can geek out on them for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also right down there in the description box. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.